Good morning and welcome back to this proceeding before the Public Service Commission of South Carolina in docket 2022-238-E. Let's take a roll call of commissioners. We have Commissioner Irvin virtually, and in the hearing room we have Commissioner Justin Williams, Vice Chair Powers, Commissioner Thomas, Commissioner Caston, Commissioner Carolee Williams, and Chair Belser. We just finished with cross-examination and we are now on commissioner questions. Thought I'd forgot about that, didn't you, Mr. Cooper?
Chair, I had every confidence.
May I interrupt briefly, just to let the chair...
Oh, Mr. Burns.
Pardon me. Just wanted to let you know that Mr. Bland Holman, who is also a representative of CCBA, has joined virtually, and he's just listening in. I don't expect he'll play a part in the proceedings, but I think he's admitted virtually. So
Thank
I
you.
wanted to make sure y'all knew that.
Thank you, Mr. Burns, and welcome, Mr. Holman. Commissioners, Commissioner Justin Williams.
Thank you, Madam Chair. Good morning, Ms. Best. Thanks for joining us this morning.
Good morning. Based
on the approximately 1 hour and a half testimony from this morning, what do you believe the value of a CPRE program in South Carolina is for DESC?
I know that Act 62 envisions a CPRE, and I know that it allows the commission an opportunity to I guess, ask us to file a program. I think, and this is probably consistent with what I've read in ORS Witness Morgan's testimony, I believe what's more beneficial and what's more best practices is really more of a technology neutral, where you actually really define the specific need. And once you define the specific need, then you can tailor the specific competitive procurement around that. And that could be renewable energy, but to have a, and because every RFP is unique, to have something on the shelf, I don't think is valuable, because I'm not sure what you're putting on that shelf. And I hope I answered your question.
I think you did. I'm going to interpret it using my words and see whether or not you agree with me.
That would be good.
It sounds like what I'm hearing from you is that in DESC's balancing authority, a CPRE program has little to no value as compared to a all-source procurement process.
It would be my testimony that an all-source is superior.
That's fair. Thank you. No further questions, Madam Chair.
Thank you, Commissioner Williams. Vice Chair Powers.
Thank you, Madam Chair. How you holding up?
I'm doing well. I hope you are.
Good. In the questioning, I'm not sure which was, I think Ms. Clancy for sure, and maybe some of the other testimony, you kept talking about the public interest. And of course, you know, we have the public law, Act 62, to deal with. How do you differentiate the public interest from the interest of the ratepayers and the interest of the Dominion's stockholders?
If I were to define public interest, I would say a public interest is the ability to lower system cost. And if you have the ability to lower system cost, then that would be in the public interest, right? And so I think that by doing that, we have mechanisms in place to do that. One is the avoided cost. If we can deliver below avoided cost, that would be, in my mind, in the public interest. And if we have the ability to procure capacity, if we fall below our window reserve margin, then it would be in the public interest that we pursue something for capacity. So that's what I meant by, at least that is me as non-attorney interpreting the definition of public interest. I hope I answered your question.
Partially.
Yes, sir.
The other part was that, you know, you said public interest. Can you differentiate what the public interest is as to the interest of ratepayers and as to the interest of stockholders? And how does the CPRE program relate to any of that?
Well, I think the CPRE program, as it relates to the ratepayers or to our customers, they're going to want to have the greatest value, and the greatest value would be, are we operating our system reliably and economically? And so I believe implementing a CPRE program right now, based on the framework we already have, would bear burden to the cost of the ratepayers, because because we have the opportunity to charge the ratepayers for the cost of these programs and the time and expense that it would take for the commission to hear that program. I don't believe that that would be in the benefit of the ratepayer itself. As it relates to the shareholder, the shareholder is just assuming that we're operating our business as it's intended, as it's statutorily operated, and then they're investing their money based on whether or not that they feel that we are a viable, a sustainable, a reliable system.
So the public interest would be the same as the interest of the ratepayers and pretty much the interest of the stockholders as well,
Yes, sir.
shareholders. The other word that kind of caught me when your testimony has come up several times, you keep saying that Dominion has the framework in place. And I think what parties are wondering is what the cost of having a CPR program ready, and whereas you use the word framework, I'm thinking the word, what would it cost Dominion to kind of have it in the queue? Or do you consider having the framework the same as having it in the queue, ready to kick off or ready to go?
I think that's a good question. I would say that the first question would be, perhaps if I can offer a little latitude, what is the cost of the ERCOT RFP? Anytime you engage an independent evaluator and monitor or an independent administrator, anytime you invite, it's going to be costing you third-party consultant money. I identified 8 different departments within our organization that we leverage to kind of help us successfully navigate the waters through an RFP. There are multiple stakeholders. There's the commission and ORS's time and resources. If I were to ask for a dollar figure, I would say just for the independent evaluator and monitor, it's somewhere in the neighborhood of $300,000 to $400,000. So for us to go through this exercise just for a competitive procurement of renewable energy when there is not a need, in my mind, would be cost burdening the customer.
Do you not think that Act 62 pretty much signifies that that's where the state public interest is, the public law is? They want you to head in that direction, is using as much of it as possible?
I think Act 62, and again, this is my interpretation as a non-attorney, there are several dockets that are in Act 62, whether it be avoided costs, whether it be Q reform, whether it be a CPRE program, if we opt to implement one of these programs, whether it be the voluntary renewable opportunities. There are multiple programs that are trying to advance renewables in the state of South Carolina, so I absolutely agree with you.
Okay. So the initial cost that Dominion would like to avoid at this point in time would be a contract with an independent administrator, or having to have that cost spent, or is there other costs that you think would be involved having it in the queue?
Yeah, I believe that if we were to engage one now, it would be duplicative of the process that we just completed with the ERCOT RFP.
Okay. Forget about the money. Let's talk about time frames to have it in the queue. What would be the time frame, do you think, for Dominion? Let's say the commission said you got to have one. What do you think the time frame would be to create one? Or if we said we want you to have one when necessary, is there a time frame in your mind that could help me with?
I think that's a bit of a subjective question, because it really, and I think I mentioned that before, as far as what is the specific need, but I believe that we could quickly turn a program around just because we already have a framework from the partial settlement agreement as well as the work that was done to execute the RFP. It would not be 6 to 8 months, I don't think, as described by maybe in the other witnesses. I believe it would be considerably less.
Okay. Well, and that's, what does the word quickly mean to you? If it's not 6 to 8 months,
I believe it could be done in 3 months or less.
okay. Okay. Well, thank you so much.
Thank you, sir.
And thank you for the work you've done in this testimony and stuff. It really was helpful.
I hope I answered your questions.
Thank you, Madam Chair.
Thank you.
Commissioner Caston.
Thank you, Madam Chair. Good morning, Ms. Best.
Good morning to you.
In all the question and answers, and I'm going to put this in my words and tell me if this is my understanding, tell me if I'm correct, at least what I think I've heard you say. All source technology neutral. Again, I know what it means to me, but that's me. Is all source technology neutral, whether that's in the RFP or however you do it, mean no one particular generation source or type, but any generation source that meets specific criteria and needs of the utility, such as reliability, dispatchability, cost, so forth, et cetera? Is that what we mean by all source technology neutral?
So I would probably separate all source and technology neutral, and why I'm suggesting that is because when you develop the criteria, the standard evaluation criteria, whether it be price or non-price, and you just mentioned several of the non-price criteria that we would consider, that is what you're looking at it from a technology neutral standpoint. What characteristics needs to be delivered based on the solution, and then you can define the sources, all the sources that meet that minimum criteria. So I would say first look at what is the technology neutral criteria, that everyone will create a level playing field, and then from that you determine what all sources can deliver that specific characteristic.
Got it. Makes sense, and I understand that. Thank you.
Sir.
And you seem to be of the opinion, based on what I've heard, that a technology neutral process balances the cost of potential generation sources available and the operational needs of the utility. Is that correct?
Yes, sir.
And I think you said something along these lines, that if, you didn't say this, but in reference to some questions, I think from Mr. Burns, that if South Carolina had laws that mandated that the electric utility use a CPR program or required the utility use solar generation, then this would have some effect in the direction of Dominion South Carolina's decisions. Is that a true statement?
Yes, sir, and I believe if we were mandated, we could have utilized the process that we did in the ERCOT all-source RFP, because we had the parties that needed to help us design that. We could have become efficient, and we could have done two types of programs. We would have had the all-source ERCOT RFP that we executed, and then we would leverage the knowledge from that and create a parallel path for renewable energy. But absent that mandate, that really wasn't necessary at the time. But to answer your question, yes, sir, that would have been what we would have done.
And your answer actually got my next question, which I was thinking, how did she see that?
We're planners.
It said, basically, I guess what I was going to say, or the question was the ERCOT, and it's ERCOT, right?
Yes, sir. Spell
I'm with Mr. Burns on that, like spell it the way it sounds. Process proved this and provided the physical and empirical evidence. Is that what you're saying?
Would you repeat that question one more time? I apologize.
That the ERCOT process you have mentioned many times, and you did in your rebuttal and your direct, just by going through the process with the stakeholders and the empirical evidence, after doing it and completing it, I guess you're saying based on that, it makes your point or argument that this works, or it can be modified to fit if a CPRE program is needed or required for just renewables, it can be adapted to that. Is that what you're saying?
Can. Yes, sir.
And what I think I heard you say in response to Commissioner Justin Williams' question, and what I think I've heard through all the questions, and do not let me put words in your mouth. All things considered and equal, Dominion's kind of figured out how this should work, technology neutral is the best way to go. And in essence, a CPRE program is really not necessary specifically to do these things.
In my opinion, and based on the experience that we had with this Urquhart, and I will give Charles Rivers Associates some credit. You'll hear some more when that docket comes about. They have experience. They were able to deliver us documents, solicitation documents, criteria, scoring criteria, extremely helpful in developing that because we started from scratch. And you can tell how long it took us to do this together in parallel with a seasoned moderator. But no, I do not at this time think that a competitive procurement for renewable energy, absent any legislation, is really the best course for the commission to approve.
Okay. And I think it was in the questioning. I think it was with Ms. Clancy. I can't recall. The question back and forth talking about about Dominion's corporate policies, and Dominion Virginia and all was mentioned, and it just kind of caught my attention a little bit. But let me ask you this question: does Dominion South Carolina's corporate goals still focus on reliability and least costs, or does it prioritize carbon-free generation over cost to the ratepayers?
I can say that Dominion Energy Corporate has targets that they're trying to achieve and that they have committed to achieving, but I will assure you that Dominion Energy South Carolina will operate a safe and reliable system, and that's going to take precedent because we are statutorily required to deliver economic and reliable service, and we will not compromise our reliability from a carbon reduction standpoint.
Does that include least cost of the most economical?
An IRP balances obviously the most reasonable and prudent, but least cost is definitely important because that's delivering value to our ratepayers by running the system economically.
I know this is probably going to break your heart, but I really don't have any more questions right now. So.
Well, thank you very much.
Thank you, ma'am.
Commissioner Thomas?
Thank you. Thank you. And thank you, Ms. Bess, for your testimony this morning. I think that most of my questions have already been answered, but I have one, and to me it's kind of high level. So the balancing authority area has been mentioned a few times, and I have a question about that and how that relates to your service territory or your service area. Can you kind of go over that a little bit for me?
I'm going to, in my knowledge, I'm going to equate those to be basically the same. I mean, we have our transmission group that talks about it as a balancing authority area, but it's really recognizing what are we trying to serve in our own service territory. We do have interconnections with other utilities, but in my simplistic mind from an IRP planning, because I'm not a transmission modeler, I view that as our service territory. Okay. Subject to check, so that I might be corrected when I get back to the office.
Well, I don't know, but I guess the question, the reason I asked the question is if the balancing area authority is different from the service territory, and I don't know whether it is or isn't, but let's just assume for a minute that maybe they are not the same. I was just kind of trying to figure out then if you're putting renewable energy somewhere other than in your, can you do that? I don't know, it's a theoretical question, and just wondering.
Well, I would say that for purposes of the Urquhart RFP, one of the requirements for the capacity piece was that it had the ability to interconnect to our system and actually at the capacity at the Urquhart location. So I do know that when I think in terms of the balancing area authority, it has to do with the interconnections of our distribution and transmission systems, i.e. service territory for a layman person like myself.
Okay. And just out of curiosity, where is the unpronounceable Urquhart?
Where is that?
Yeah.
I have not been to Urquhart, so I apologize. I can't give you with great certainty where it is.
Okay. I was just kind of a general area.
It would have been nice for me to have put a map of that, I believe, and I'm sure whenever you walk through the replacement technology, Mr. Andrew Walker, who I'm sure will be a witness, will be able to guide you that. He's very good with Google Maps.
All right. Thank you. That's all I
Thank you
have.
so much.
Commissioner Carol Lee Williams.
Thank you, Chair Belser. And good morning. Good to meet you in person.
Good to
And
meet
you and
you.
I may do a dance back and forth to be able to see each other.
I'm happy to slide my chair if I need to.
Yeah, that's it, Joe. Okay. So I'm going to get into the Urquhart game and tell you all that every time I hear the word, I think of Scotland and the Loch Ness Monster. But so I don't get into the use or the pronunciation. And I think that's a totally different spelling, but that's where my head goes. You talked a lot about Urquhart and the process, and it's been referenced that stakeholders in the room participated. Would you define who some of the participants were, whether they're in the room or not in the room?
Well, we had representation from CCEVA, CCL, SACE, and the ORS. We had not only some of the witnesses that are in the room, but also the legal counsel. That's what I meant by many of the parties that are in the room. So I think those folks would give you the opportunity to give a feel from their perspective of how collaborative that process was.
Okay.
And if you need me to be more specific, I can. But we did have representation from all of the intervening parties.
All of them.
Yes.
And just to include a few other names of folks that perhaps are not interveners, but were key participants. I'm just curious.
The lion's share of the folks that were interested parties that were, because they were potential bid respondents, were those organizations that I mentioned.
Okay. It may take me a while to form my questions, so hang on just a minute. As I listen to the conversation, it strikes me that there's an overall process that may have been developed in the Urquhart matter, but there are specifics that may be different. Is that fair? Or talk to me some about kind of the relationship between what you established so that we can understand a little bit better what you established in this process that is going to be transferable. But because I wonder how much of that is in writing and understood by all the parties.
I think that's a fair question. So let's first start with the partial settlement agreement that was
Right.
that occurred. So there were I say there's 4 key takeaways from that. One is that there was an agreement to use a third party, and we specifically used Charles Rivers Associates as an independent evaluator and monitor. So we were able to define the specific roles that were to be engaged by them. What would they do? What would they bring to the table? The second thing was that we all agreed that it extended beyond capacity. So capacity was a minimum requirement, but we wanted it to have, which was a third point, was broad technology. So if you minimally define the capacity but broadly allow for the participation, some of those solar projects that we've been talking about had the opportunity to competitively bid in a transparent, fair, and consistent basis. So those are the first 3. And then the fourth is that the bids were either, and I apologize for reading, but I wanted to make sure I had a note for you, that either bid individually or in combination. And it also said that the portfolios could be constructed of resources that in combination means the system. So what that means is you didn't have to develop and bring forth a full project. We were able to, through this process, consolidate, combine, and bring forth multiple portfolios to find the best solution for the system. So we evaluated the projects on a product basis, on a like-kind basis. So solar were compared with solar, hybrids were compared with hybrid, standalone was compared with standalone. And then we did a resource optimization with our system called a portfolio analysis. So that's how we were able to bring a good solution that was technology neutral, but all source. So those 4 key points from that partial settlement agreement, in my mind, was the framework to develop a really good program. And then having a partner like Charles Rivers Associates was very valuable because they had experience and was able to bring in many of some template documents that they had from other prior procurements.
Thank you. So continuing, building on that, what's the next step? Should you have a capacity need or have an economic need? How would you build on the framework that you just described?
I think that's a fair question. So because the commission is going to have an opportunity to review and approve our 23 IRP during our proceeding in this August. But using the 21 IRP as an example, we just recently did the competitive procurement for ERCOT. That gave us an opportunity to test the waters to get actual bid data. Okay. We're also talking about doing a 23 RFP to evaluate replacement options for Watery. And by doing that, we'll also allow a second opportunity for those same projects to sharpen their pencils a bit more and to come back in again from a competitive procurement to develop. So those are two opportunities, and those are actually execution of a framework that we've already created.
I meant it more from the angle of you've got the framework. You talked about templates, for example, that Charles Rivers
Associates
that they brought. Would there be templates in the CPRE process that an independent, I'll just call them an advisor because I'm struggling between, let's see, monitor and
an independent administrator.
Administrator.
Yes. So again, I'm referencing some notes from some of the prior testimony. We have 8 different RFP documents that were actually developed from this process. The only thing that we really don't have at this point in time would be a form PPA, and that form PPA would really be specific. Now, I also testified that we have executed 46 PPAs, so we have experience in that. That would not take a long time, but we've got a primary solicitation document. We have a notice of intent form. We have a non-disclosure agreement that we used for all parties. We had a pre-qualification application. We had a preferred technical specification by technology. We had key commercial terms. We had a standard RFP response form, and we had an RFP evaluation criteria. All of those was reviewed with all the parties that I mentioned before. So there was consensus built on that. The fact that we're not coming in front of the commission says that we had consensus. That's saving valuable time and resources, but those documents themselves, plus a form PPA, et cetera, is what's really needed to be in place. So there's the templates that you're asking about.
Is it your belief that that is all that's needed for a CPRE process?
I think it's all that's needed for a framework. And then at the time when we have decided and the commission has agreed that we have a need, then we would tailor that framework for the specific need. To Commissioner Caston's question, the difference between an all source and a technology neutral, we would then figure out what are the standard evaluation criteria that we need, develop the program specifically tailored to that, changing the rules lightly, and then executing that.
I mentioned, and you talked about economic need and capacity need. I guess this is an IRP question, really. And I realize that could mean a really deep, long question, and I don't want to go there. But could you talk about how you prioritize? Are there, if there's this capacity need, then you look at economic need. How do you balance them? How do you?
So that'll be a great modeling question when we come to see you in August, and Mr. Jim Neely will be able to explain that. But our Plexos models optimize, and what they do is they're looking at the questions that you're just asking. At what point do we need capacity, and what is that lowest cost capacity that meets that need? And then it'll also look at what are the energy needs and requirements, and if at some point in time it selects something based, again, on the prices that are modeled. it would select it. So it's not an either or, the system itself optimizes it.
Okay. Thank you for that refresher. We were brand new when we were first looking at and hearing about the Plexus
And
model.
I'm very proud of some very talented people that you're here from. I lead that team. I am not a modeler.
Okay. Okay. Talk to me a little bit about the impact of the volatility of fuel, because we're clearly in a point where that's made a big difference. I don't have a real specific question to ask you there, but I do see the relationship between fuel volatility and a resource that is not volatile. Is there sense that we won't have that volatility again? How important is that?
I think that's a good question, and I'm responding based on my opinion. I think we would agree that in the middle of 2021 through the end of last year, we saw extreme volatility. And it wasn't just Dominion Energy South Carolina. Many utilities saw that. We saw that every time we went to the gas station to fill up our car. Right. But if you were to go back 10 years, or if you're looking at the future forward curve of maybe natural gas and coal, you're going to see more stability than that disruption that you saw in the middle of 21 and 22. The beautiful thing about, and I went back and I mentioned the avoided cost docket, the beautiful thing about that is the Commission has the opportunity every 2 years to look at how we are calculating that accurately. Is it reasonable and just? Are we giving a level playing field for those small power producers? And so I believe that we're doing our part, and I believe the Commission has been doing a great job in their part as well to ensure that based on the information that we have at hand, we're making the decisions that's the right decision for our customers and how we run our system. Can I tell you with certainty that we're not going to have something like we've seen over the last 18 months? No, ma'am, I cannot. But I can tell you that we do everything within our power to run our system reliably and economically.
Thank you. I'm going to check my notes. I know I have more questions, but I'm also going to give an opportunity because I think I heard Commissioner Irvin at the very beginning state an interest. So I'm going to take a pause, and if he has questions, I'll continue questioning later.
Commissioners?
Madam Chair,
Commissioner Irvin?
thank you, and thank you, Commissioner Carolee Williams. I wanted Ms. Best to revisit the moderator that you work with the stakeholders, and ask you, did you all discuss some of the challenges that are facing the solar industry as it relates to supply chain issues? Did that create some volatility in solar panel pricing, that kind of thing?
We didn't specifically discuss the question that you asked. We did allow, pardon me, for a very robust discussion so that all voices are heard. I can't say with certainty that it would have to be subject to memory or go back to the minutes. We did take comprehensive minutes of each of those. I don't recall the supply chain discussion coming up, but what I will tell you is with the fact that we use the NREL 2022 ATB as our source for modeling absent market data, the fact that the pricing came in higher than that would probably suggest that that does incorporate some level of the supply chain challenges that the solar industry has faced.
Thank you for that answer. And I guess in a perfect world, some of those supply chain issues might resolve the next 9 months to a year if certain things happen. Is that what Charles River Associates indicated, or do you recall?
I would say that if supply chain starts to stabilize, then yes, I would expect some of those costs potentially to come down. I would also mention that we recently filed our avoided cost docket, which the Commission will be hearing soon. If those rates are approved, that will provide another opportunity with more current avoided cost rates for the solar developers or the small power producers to participate. I'll also say, Commissioner, that That's just for our standard offer. If someone comes to us as a company to negotiate a purchase power agreement, we do update our costs. So there is accurate cost modeling to allow for an equal opportunity in a non-discriminatory fashion.
Very good. And it sounds to me like the stakeholder process is working well. Would you agree with that?
We have had very robust, and I believe you have been one of the folks that has introduced and suggested that. I personally have participated in 11 stakeholder advisory meetings for the IRP. I have participated in 5 stakeholder sessions for this ERCART, and I have had the pleasure of sitting in the energy efficiency advisory group, because many of the parties that participate in that also participate in the others. So I would say that we have built some serious relationships along the way. Yes, sir.
Well, that's great news to hear, because, you know, time does not permit the commission really to delve into the intricate details of some of these issues. Unfortunately, we have other dockets that we are waiting hearings, and we don't have the benefit of an expert like Charles River Associates that could come in and give you updated information. Did they also provide you with some updated cost information as it relates to various sourcing?
No, sir, those were done independently by the bidders.
By the bidders themselves?
Yes, sir, but they did manage the communication with the bidders. I mean, we kept it very, there were non-disclosures in there. We were not given specific project information. We were able to do the optimization based on what their criteria was.
Right, so you have, with the non-disclosure agreement, you think you got real numbers?
Yes, sir, we do believe.
Yeah, and that could be relied upon in a modeling
yes,
like
sir.
this.
And that's what we would be using as we're modeling our 24 update, because we now have real market bid data that, in my mind, would supersede something that may not we have realized in our service territory.
Very good. And I guess it takes a good deal of effort to keep that pricing quotes, keep that information updated and current. Is that true?
We don't actually maintain and keep the pricing information ourselves, but we do have ongoing conversations with the developers. We have teams of folks so that, you know, we have these conversations that when they have an opportunity to bring a project to us, we certainly work with them.
Very good. Because things can happen quickly in a world economy. We've seen that many times. And so maybe if we're fortunate, some of these issues that have slowed utility-owned solar due to cost increases because of supply chain issues and the like, maybe some of those issues they'll get revisited as circumstances change. Is that fair to say?
Yes, sir. I'm hopeful that the disruptions that we've been talking about between fuel and supply chain will certainly subside soon.
Well, thank you very much. And again, please pass along my interest in knowing that the stakeholder process is working as well as it is. I'm impressed by the number of times you met and by the cooperative spirit, and I think that that bodes well for us going forward. Thank you again.
Thank you, sir.
Thank you, Commissioner. Commissioner Justin Williams, do you have further questions?
Yes, ma'am. Thank you, Madam Chair. Ms. Best, a few more questions came to my mind. I'm trying to make sure I understand the value of a CPRE program, generally speaking. I understand that your testimony is all source procurement is superior to a CPRE program. Am I understanding that correctly?
Yes, sir. Absent legislation, I would argue, and maybe I'm going in the direction that you're thinking, I believe the value of a CPRE is if we were to have some type of renewable portfolio standard or some other type of legislative action or policy. If that were in place, and I absolutely think that that would be required and needed for us to be able to ensure that we are successful in how we're being mandated to operate our system.
Right. For example, if you were legislatively mandated to bring on a certain amount of renewable energy into your generational mix.
We would be all about figuring out how to solve that.
Okay. But that's not the case in South Carolina.
No, sir, it is not.
So, I mean, it could be argued that if the company has decided that CPRE is not in the best interest or not in the public interest, it would be illegal for you all, even if you thought it would be a good idea for some other reason. It would be illegal for you all to put forth a CPRE program if you thought it was not in the best interest or the public interest.
I can't speak that if it's of the legality, but what I can say is that if we brought something forth to you that was higher than our avoided cost or our system cost, then I would assume that you would reject that because we're not doing something that is providing value to our customers or in running our business.
So without a legislative mandate, is it possible for a CPRE program to have much value compared to a all-source procurement program in South Carolina without because we don't have a legislative mandate for renewable energy in South Carolina at present?
I'm not sure the value, if we went forth and did a competitive procurement for renewable energy today and actually executed, not just developed the program, but executed it and brought it to you, we would be doing the same thing that we just did. And chances are we may be delivering projects that may or may not be above avoided cost. And then the question bears is, should we be incorporating that solar or that other type of renewable source into our system? Because again, we've been challenged with the intermittency and how do we maintain the reliability. In anything that you do that, then you have to revisit how do you manage the system to account for that.
Okay, thank you for that. Now, and you've been very careful with your testimony in that you don't believe that a CPRE program is in the public interest at present.
That's correct.
Could you flesh that out a little bit more and illustrate or paint a picture for me as to when it would be in the public interest?
So I think I laid out in my testimony that says it's in the public interest when first we define it as a need. And then that need is substantial. And then we would develop established guidelines, and then we would execute a program, and we would come to the commission to say that we have that. So let's assume that's the case. Let's assume that the 2021 IRP update had a more material amount of solar that was in those plans. So let's assume that it was more than the 50 megawatts in those 2 years, and we agree that it was substantial enough. Then we probably would have felt obligated to come to the commission to develop a competitive procurement for renewable energy. But because we, in parallel of doing the 23 IRP, went through the time, the collaboration, and the expense to develop the ERCOT RFP, the opportunity for those renewable energy projects to come forward was in that forum. But not for that, maybe my testimony would have been different. But right now, we have demonstrated, one, there's not a public interest in the 2022 IRP update, and two, at this time, in parallel to the filing of our 23 IRP, we have done a procurement that in current costs, we have market bid data that suggests that it is not in the public interest. So I believe we've demonstrated that.
I don't disagree. I'm trying to work through this based on what my understanding was before your testimony and what my understanding is now. Based on everything you've just said, as a planner, when in the next 3, 5, 7, 10 years, when will a CPRE program be in the public interest? Will it ever be in the public interest?
Well, and if you're asking my opinion, if I believe, and I believe witness Morgan has testified that as well in his direct testimony, that a technology neutral is superior by defining the specific criteria, that may or may not be a renewable energy, it may or may not be some other source. But I'm saying is if we look at it from a superior perspective, and that means a technology neutral, and then allow all sources that meet that minimum criteria to procure, to me, you would get a better value than you would be just doing a CPRE in isolation.
Thank you, ma'am. Thank you, Madam Chair.
Thank you, Commissioner. Commissioner Carolee Williams.
Thank you, Chair Belzer. Thank you for your patience and everybody's patience as I get back to my questions. You have talked a lot with Attorney Burns and now with Commissioner Williams about substantial enough and justifiable. Talk some more. Maybe you've covered that ground before. Is there a formula? Is there a ratio? Is it just a instinct?
I'm glad you asked that question because I thought to myself someone would. So I appreciate you asking that. I mean, what defines substantial?
Right.
I would say that we recently did the ERCOT RFP, and that was for 193 megawatts of capacity. So I would think that that would be a threshold that we might look at to say could be substantial. That might trigger a competitive procurement. The 50 megawatts that we're seeing in the 2-year tranches in the 21 IRP, I would not say is substantial. But anything, in the 200 megawatts, and again, that's subjective, I believe would be a good threshold for us to be considering.
Would that be a good good question to work through with the stakeholders, or have you already done that?
We have not done that part, at least not in this exercise, because this was for a specific replacement generation capacity. But again, we have constant conversations, as Commissioner Irvin mentioned, with the stakeholders, and that certainly would be an opportunity for us to discuss and to mutually agree on it at some point.
And is there any reason for the commission to tell you to do it, or is it just a good business practice to?
But we've committed in our 23 IRP to hold at least 2 to 3 stakeholder meetings, and at this point we've had 11. Those 11 have covered many priority topics that we've already covered, and so we're now to the point where I feel like our process is mature, and so now we're seeking from them to understand what are things that we need to be discussing as a group to make sure that we're developing a very we're bringing to you our best product forward. And so this may be a priority topic that we may add to one of our future stakeholder meetings.
Would you like to elaborate any more on your answer from the aspect of, you said 50 is, from your personal opinion, is too low, and 200 or more would clearly be impactful. Is there more you want to add to that in terms of what that means from a threshold or an impact perspective?
To be totally honest with you, I don't have a whole lot more than that because, again, I think it really is specific and unique to whatever it is the need that we're trying to solve. We're here before you now. You're going to hear a proceeding for the ERCOT RFP. There's a lot of time and attention, and I know that you folks have been through a lot from your schedules and your time. For me to tell you there's a specific number and then we come back to you on that when I believe we can deliver something at or above that level, I wouldn't want to put that on the record.
Okay. I understand and I appreciate that.
Thank you.
In your discussion with Attorney Clancy, this is just a curiosity thing. In passing, you referenced ERCOT and an RFP and 25, 26, 27. Was that months?
No, that's commercial operation dates. So our projects that bid in, they're telling us when can they deliver commercial operation projects. And so there were many projects that bid in, and we had several that could have delivered commercial operation or can deliver if they are selected to advance forward, which is encouraging because that tells us that we've got projects that are out there in our interconnection queue that are advance of this queue reform. And not only are they advance of the queue reform, they may be just having delays in the supply chain that Commissioner Irvin said. If they're having trouble getting the panels, they need to construct it. So, I mean, I'm not sure what are the delays, but we have quite a bit still in our interconnection queue.
Thank you. Tell me if this is what I read in your direct testimony. I think you said that all source renewable RFP is appropriate at that point. But then when you got to your rebuttal, the new information had evolved and your testimony changed. Is that true? Is that fair?
I don't know if I would say my testimony changed. I would say in my direct, I'm addressing this particular docket, and this particular docket is related to a CPRE. So if you were saying, Ms. Best, what is preferable to a CPRE, then I would definitely say all source. But I believe one of the attorneys, and I forget which one, mentioned that, well, right now, solar would be the only thing that would have bid in. So if solar is the only renewable source, and that really is a single source, the economics of the different projects won't vary, so all we're considering is the non-price. Then the question begs, is it the right thing for us to add to our system, and is it lowering system costs? So I'm circling back to the answer to your question. My direct was answering the question as the docket specific, CPRE. My rebuttal basically said an all-source technology neutral procurement is superior, in my opinion, to any procurement process.
I think you've answered this, but I'm going to give you a second chance on it. This has to do with kind of at a bigger picture level. Why do you think the solar prices have gone up? I think you've testified that you know through this RFP process that you've got demonstrated dollars that have changed.
Yeah. What I would say is, I don't know if I would say the solar prices have gone up. Maybe they have. Maybe they have because of the difficulty of getting solar panels. What I would say is that from our analysis, the NREL ATB had aggressive forecasts, and those aggressive forecasts was assuming the reduction of costs. So I don't necessarily say that the prices went up. I believe that the forecast that we used, that we agreed upon with our stakeholders, was aggressive and is not what we're able to realize currently inside of our balancing authority area today. And I'm sure that question will come up again for witness Neely in our IRP docket, but that's what we discovered when we started digging a little bit deeper into the NREL ATB forecast.
Thank you. I may have one other question, but I know there's another question coming, and I'm going to look for that for my last one while that question's coming.
Thank you.
Commissioner Caston?
Just one follow-up question. I think it was page 3, your rebuttal, where you talk about, what you've said many times, learning what's occurred with your Urquhart project, that you believe what's been learned there would be ample time if it needed to be transformed, modified, or whatever into a CPRE program. And well, depending on where you look, the top of the left, page 7 of 19 of the application and pleading, about the middle way down, it talks about whatever the design, executing the successful CPRE process is time-consuming, expensive, and labor-intensive. As such, the decision to initiate a CPRE must be carefully evaluated and made only after showing of a utility identified need for sufficient magnitude to justify such an undertaking. As I was thinking about that, on the one hand, you say what you've learned, or what Dominion has learned, is that you could, if needed, you could transition into that pretty quickly. And the application pleading says, it's pretty complicated, it's time-consuming, expensive, and labor-intensive. Are those contradictory statements?
No, sir. I believe that the initial pleading was written as if we were to develop one from scratch. We are now in an Urquhart process, and I think you can appreciate as a planner that when you develop a plan, those plans get refined. They're snapshots in time. As we get better information, we adjust, we adapt, and we comply. And so I would say that one builds off the other.
She's good. Thank you, Ms. Best.
Thank you.
Ms. Best,
Madam Chair?
I'm going to jump ahead since some people have had more than one bite at the apple here. So, tell me what you think a CPR program is.
A CPRE program? What do I
Yes,
think
CPRE
about this?
program.
I think well, first, it's a competitive procurement. So it should be competitively procuring among certain resources. If it's a renewable energy resource, then it is competitively procuring against technology-ready renewable energy resources today. And as I define renewable energy, as I understand it, that's going to be solar, wind, biomass. So you would be looking to see from a technology neutral, can a solar, a wind, or a biomass project satisfy whatever that specific need is that has been identified through some IRP planning process or some other process or some statutory process that has been mandated. So to answer your question, you are looking to see, can you solve competitively comparing solar, wind, and biomass with each other a specific need.
Okay. And for purposes here, I misstated when I said CP. I left off the E, but I'm talking about CPRE because that's what
Caucus.
we're here today about. And you've discussed the Urquhart procurement and that y'all have learned a good bit from that process and the use of the third-party administrator and templates. You have templates. And as I understand your testimony, from what y'all learned with that Urquhart process, as you have to do competitive procurements in the future, you hope to build upon what you've already learned.
Yes, ma'am.
Okay. Is it your understanding or that a CPRE program is only identified or built when there is a specific need identified
For renewable energy.
for renewable? Well, I reckon where I'm going is it not prudent to lay the groundwork of what would need to be in a CPRE program for renewable to have the overall structure in place so that when a need is identified, that it could be implemented easily and quickly.
And Commissioner Castor might have given me credit if I haven't communicated that well. I believe that we already have that in place. We already have the template documents. It's just a matter of changing a little bit of the rules as far as what that standard criteria. So when we talk about price and non-price criteria, the non-price criteria for an all source might be dispatchability. It might be reliability. It could be locational. There are several things that a non-price criteria could be. Limiting that scope where those non-price criteria does not involve those would then be able to tailor it specific to a renewable energy type. So then economics is compared for those renewable energies, and then the non-price might be maybe there's a couple of different things you can think about. It's project and it's bidder. The bidder is, what is their operational experience? And again, this was all considered in the Urquhart RFP. Have they had any power for quality issues? There are location specific things. There is environmental compliance. There's a lot of things that we can do to tailor and specifically refine what we currently have in place that is specific to a renewable energy type project. I don't know if I answered your question.
Well, and I'm kind of going and maybe it's the lessons learned. If just say the commission said, give us the specifics that you would have in a renewable energy competitive procurement program, so that if you had to put it out, there's no need. We want to know what the process would be, what the documents would be. Is that something that could be done so that it is ready when the need is identified to launch that procurement?
I believe that Charles Rivers Associate is going to be writing a report that we'll be filing with our testimony, and in that testimony it will lay out the actual framework, the guidelines, and then the product, the selection, the scoring criteria. That right there itself is an example of something that would be delivered to the commission to know where we go from there.
And that is the process that Dominion is contemplating using should the should a CPRE for competitive renewable energy program be needed.
Yeah, what we have learned from Charles Rivers Associate is that a typical independent evaluator and monitor, which is what we believe is the balance of what you need, an independent evaluator, administrator, which we haven't talked about, they're going to manage the entire process. What ORS Witness Morgan described and what we're advocating for is an independent evaluator and monitor. And what we have learned from Charles Rivers Associates is that independent monitor, they deliver the solicitation, they deliver the criteria, and they deliver the scoring criteria. They work with the company to make sure that we develop something that is transparent so that when we deliver it to the respondents or the bidders, it's on a level playing field. So that process is a very mature process, and we have worked with a mature partner to know how to do that and implement that very quickly. So I'm not sure if I'm answering your question specifically because I'm not putting a document in front of you that says this is it, but I believe once you have an opportunity to read the report from Charles Rivers Associates, it'll become clear to you the framework that I have been trying to articulate either successfully or unsuccessfully.
And that's going to be in the Urquhart docket.
Yes, ma'am, that will be.
And do y'all have a potential date for conclusion of that where you would be filing something with the commission?
I believe that will be filed more toward the end of this month, subject to check.
End of this month?
I believe there's a testimony could be filed, I think, as early
It's
as
that far
again,
along?
We are in the what they refer to as the definitive agreement negotiation stage, but we are in a position to summarize a report that we will be filing with the commission.
Okay. Well, I mean, would you consider it a best practice to use the independent administrator and monitor, even if Dominion were not seeking to bid into a procurement? Let's just talk generally the procurement.
Okay.
If Dominion was not seeking to either self-bid or have an affiliate bid into the process, would it be Dominion's position, do you think, that the independent administrator monitor would still be needed?
So I'm going to use the term independent evaluator and monitor, which
Okay.
is different than the administrator.
There are a lot of terms here I don't know.
Yeah, no. I had to get trained up on it as well to be able to come in front of y'all today. But the independent evaluator and monitor is what we think is a good strike of the balance of the two. One, because it's ensuring a transparent and fair and consistent process. Now, if the company were not to bid, is that a necessary avenue? Perhaps not, but if you want to make sure that you are technology neutral and you're all source, why would you not have a full competitive opportunity, whether the company bids in along with others or not? We put in our testimony that we believe that we would safeguard and wall off the people that are participating. Our construction team is in Richmond. They did not even participate in the stakeholder process. So we not only did we wall them off, we had them states away. And so I believe that from an independent evaluator and monitor, that's going to give the commission the greatest comfort that we are fair, consistent, and transparent. And I believe it is a valuable resource for the company to be able to leverage the best option. But, again, it depends on the specific need that we're trying to
Well, and that's not a trick question.
Oh, I know.
I was
I
just
probably
curious.
rambled and I apologize,
You are doing well. You're fine. I just was curious as to that response. So I'm just looking at some notes here. Earlier, in response to Commissioner questions, you indicated that maybe a 50 megawatt need would not be substantial, but 200 megawatts would be. If 50 megawatts was not substantial enough to require a procurement such as what we're discussing today, how would that need be met?
Well, if that need, if the Urquhart all source is operating as it's designed, that need would be met once we finish the definitive agreement negotiation stage, because the projects that bid into that would have been projects that would have satisfied that 50 megawatt need. I also want to mention that.
Well, but that's in, excuse me, for cutting you off, so hold that thought. But those, when you're talking about those projects that bid into ERCOT, that was in response to the procurement. If you had a 50 megawatt need and that is not substantial enough to require the competitive procurement, how would that need be met? That's the question.
I would say it's probably currently being met right now through our avoided cost docket, because we've signed PPAs that are yet to come online, and we've got we have, I think, subject to check, 200 megawatts of solar and 100 megawatts of battery that's going to be coming online in 23 in the mid of 24, and then we've got 2 NOCs, notice of commitments, that have been recently signed that are commitments by the developers. So I believe that need's going to be met through our natural, I guess, process of competitive procurement in an avoided cost type of situation.
Okay. And you're giving me examples of what's happening now, and I'm just talking about that nebulous 50 watts, 50 megawatts out there in the future. Now, I interrupted you, so finish your response if you would.
No, ma'am, I was done.
Are you okay? Okay.
Yes, ma'am.
I don't want to leave it
No,
okay.
ma'am. Thank you. I appreciate that.
Okay. Thank you very much. I appreciate your responses and your attention to my questions.
Thank you, Madam Chair.
Commissioner Carolee Williams.
I do have one more, actually 2. I want to take you to page 9 of your testimony, your direct testimony. And it's a little bit related to the questions just asked of you. And as you're finding it, you talk about the Siting Act. Oh, I see the look on your face. So have you found it?
Oh, I found the page. Yes, ma'am. Thank you.
Okay.
Appreciate your patience.
No, sure. I was just making sure we were together. This really says, the same question: if CPRE is not in the public interest, what are the other options? And here you talk about the ability to procure, and the Siting Act ensures a cost-effective alternative. I think based on the whole that we've heard today, you're not saying CPRE is never the best alternative, or are you?
I'm challenging the need for the CPRE. I'm saying competitive procurement is important, and as you just referenced in the Siting Act, we do compare other generations, and then when we do our final RFP, we would be competitively procuring the technology that we found to be most cost-effective under the Siting Act that we would bring forth to the Commission. I'm just saying is that until a need has been identified for renewable energy, and
Right.
Again, I go back to the technology neutral term. If you want to get the best value for your customer and for our system, you're going to want to be agnostic to the technology. You want to make sure that you're delivering whatever that need is, and then you identify the resources that can satisfy that need. And if it's a solar project, then absolutely, we would love to have that on our system. But I'm saying let's don't limit it in this environment. I can't speak to why Act 62 in 2019 was written specifically to this, but I can tell you our system has quite a bit of solar on it, and we're getting the benefit from that solar every day. So especially when the sun is shining. So I'm an advocate for it. I just wanted you to know that I think we first need to make sure that we are solving the need first before we go directly to the technology that's going to solve it.
Thank you. I just was resolving a niggly question that I had when I read, and what your answer is certainly in the theme of what I've heard today.
I hope I did answer it.
No, you did. Of course you did. And then you referenced that in the RFP process for ERCOT, you had one of the safeguards was that Dominion would file a day ahead of time. Would you talk a little bit more about any other safeguards or how that one worked? also gets back to a previous question.
Yeah. I don't have the schedule in front of me to tell you exactly when certain, activities triggered, but the reason why we filed a day early is because you don't want to have there to be any concern or perception that if our bid was filed at the same day or later, that we would have had access to that information. So we tried to preserve the anonymity of the projects. Charles Rivers Associates they received them directly. We did not have the opportunity to look at that. We only had characteristics of the projects. They evaluated the project specific. We evaluated the portfolio optimization. So we looked at the resource optimization around the projects that they delivered. We did not have specific information around that. So that protected the commercial terms that we're trying to negotiate at this point in time. The fact that we went through a process of going through each and clarifying the standards ahead of time, those minimum evaluation criteria ahead of time, created some safeguards because you want to have a level playing field where it's unbiased and clear and transparent. So I'm not sure if I answered your question around that, but that's the reason why we filed a day early.
You did. And when you mentioned that you had, I think, characteristics, but not the individual details, you meant after you had gotten to the RFP deadline and as you were kind of evaluating capability and other factors that you would have been looking at.
We were getting information back, and I feel like I'm testifying for the ERCOT RFP prior to the actual docket in advance, and so they can fact check anything that I'm saying. But the information that was provided to Charles Rivers Associates, they were able to give us summary information that says how many megawatts bid in for solar, how many megawatts bid in for storage only, how many hybrids, how much demand response, what did those projects look like? So they were able to create some characteristics so that our modelers could then incorporate that into our Plexos modeling to determine what is the right solution for that ERCOT replacement.
And you wouldn't have had any of that before the bid deadline?
No, ma'am, not at
Right.
all.
Okay.
No, ma'am.
Thank you. No further questions, I promise.
Commissioner Justin Williams.
Ms. Best, thank you so much for your patience. I would just want to make sure I get all my questions out before you go. It sounds like to me, ma'am, that you're saying that the process that Dominion Energy South Carolina has in place now is superior to a CPRE program. Is that fair?
That would be my testimony.
And there's nothing wrong with that. You seem to tense up a little bit.
Well, I feel like we're here to talk about a docket that's for, and I'm here to answer the 8 questions that the commission asked me to respond to. But if you were to ask me what is the appropriate direction going forward, I believe a technology neutral, kind of agnostic approach, which is the approach that we did, it would be far superior than for us to have a very defined direction that in my mind may or may not deliver. I mean, if we had done this and we had created this program, and I may have said this before, and that program created something that was above avoided cost, I would not want to waste the company's time or the commission's time to bring forth something to them that I would not say would be prudent. And so I believe taking the path that I'm advocating for now, which is a little bit outside of this docket, is the approach that I think the commission should focus their time and attention.
And I appreciate it, and I really want to send this message home. We're just trying to understand, because coming into this, Act 62, we've been looking at Act 62 since May of 2019. It is now March of 2023. And so it's taken us some time to get to the CPRE portion of Act 62. I just want to make sure that you're given the opportunity to clearly state the company's position.
And I appreciate that. Thank you.
And so going a bit further, if there was a mandate for your company, DESC, to use a certain amount of renewable energy in their generational mix, that would change the framework and change the playing field. Is that fair?
Not only would it do that, it would change the assumptions in our models, because we would be all about making that happen. We would be initiating a program. Our models would be putting forth constraints as we have in some of our build plans, and we would be absolutely looking to solve whatever we have been legislatively mandated to do.
All right. So that's not our world. So
Not
we
today.
can just forget about that world for right now. So right now, what you all have done, what DESC has done with ERCOT and the stakeholder engagement, everything that you testified to, in your opinion, the company's position is that's the path forward.
That would be the path forward.
Thank you, ma'am.
Thank you.
Commissioners, anything else? Mr. Cooper, do you have a redirect?
Chair Belser, we have no redirect. This concludes the company's case at this time, and subject and in light of your admonition, we would ask that the witness please be excused.
At your peril. You know, that's my answer.
That's right, Chair. Thank you.
Ms. Best, thank you for your testimony and your patience today. You may stand down. It's a little bit before 1 o'clock, and so let's take a break for lunch. Why don't we return at 2:05? 2:05, please. Thank you. We're in recess.